Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is August 4th, and this is our 9:30 weekly meeting. As you can see, we are in a new format. The commissioners are together in a room, and we are checking our new technology for a virtual meeting in sort of a hybrid mode. We still have our participants appearing via Zoom. We have 66 participants and growing. So bear with us. We've got some new technology, and we're going to see if we can make this work today for the hybrid mode where commissioners are and staff are in a room together. I would let everyone know that we are following all safety protocols from the Department of Natural Resources. So with that, we will take our roll. Hearings Manager Larson.
Thank you, Mr. Chair. Commissioner Bogue.
Here.
Commissioner Gonzalez.
Here.
Commissioner McGowan. Here. Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Hackett.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Great. And good job with the mics, everybody, turning them on and off and not having overlapping audio. We will now move into the first part of our agenda, which is general public comment. And I believe that we had 10 people sign up for public comment. And again, the folks that are signed up for public comment are attending virtually. So we will go down our list and call upon folks. Everyone has 3 minutes to provide us public comment on issues pertinent to the Colorado Oil and Gas Conservation Commission. The folks that have signed up are familiar attendees. We look forward to attending and hearing from them. I believe the first person that signed up is Marie Venner. Do we have Ms. Venner in the room with us?
We do. She's becoming a panelist right now.
And remind everybody, we do have our timer so that you are able to see how much time you have left of your allocated 3 minutes.
Good morning, Commissioners. I'm here today from the Small Business Alliance, Moms Groups, and a statewide faith-based organization. The definition and plain meaning of assurances means providing certainty. A key change made by SB 181 and signed into law in 2019 was replacement of the term any in the previous O&G statute by every obligation. This creates expectations and requirements. With certainty would mean any and all. Thus, blanket coverage and current methodologies suggested should not be allowed. Every obligation and cost must be covered and not transferred to the public or state. The requirement to undertake an annual examination of each operator's assets to determine if the operator is financially fit to continue to do business in this state is critical. As responsible Coloradans and small businesses that do not take an extractive, take the money and run approach, leaving a mess and come what may, we find this essential. The law states that financial documents submitted by the operator must be verified and confirmed by staff evaluations. Financial assurance should include, as a starter, an examination of the company's annual profit and loss statements as reported to the SEC, which can be provided. A remediation bond is sufficient to create the certainty required in law should be required for every well. Increasing the annual well registration fee and earmarking part of the fee for 30-year failures, as well as climate change remediation. With 120,000 total wells drilled in Colorado and 60,000 that are currently on the Commission's list, the remaining 60,000 should be monitored for leaks and assigned to a responsible party, if possible, or be able to be covered with certainty out of the fund. All wells, including plugged and abandoned wells, have the potential to suffer an integrity failure at any time and become super emitters of methane and other hydrocarbons. Cornell University professor and engineer Dr. Anthony Ingraffia, who studies oil and gas well integrity, has stated 5% of wells leak immediately, and nearly all will leak within 30 years as the cement well casings and other materials break down over time. Coverage will be needed for monitoring all wells in perpetuity, identifying integrity failures as they occur, and making necessary repairs, as these companies, as we've already seen, change hands frequently and will not be accessible to us in the future. The Orphan Well Program funding needs to be substantially higher to cover this. The single well assurance amount must be required for every well upon transfer, not just the inactive wells, and increase to at least $280,000 to provide sufficient assurance of
Ms.
covering the full cost of plugging,
Sorry for interrupting, but your time.
reclamation and mediation, full cost bonding. Thank you.
Thank you, Ms. Fenner. We now will bring to the panel Tess Dowdery.
Hey, I'm so sorry. Is there any way you could come back to me in a couple people? I have to finish something real quick. I'm so sorry. Is that possible?
Yes, Ms. Dowdery, we'll put you at the end of the line.
Thank you so much. I really appreciate it.
Now bring on board David Hagan if he's with us.
Yes, unfortunately, I do not see Mr. Hagan in the meeting at the moment, so we can move to Ms. Renee Millard-Chacon.
Hello, can you hear me?
Yes, we can hear you, Ms. Chacon.
Good morning. My name is Renee Millard-Chacon. I'm Youth Program Coordinator at Spirit of the Sun, an all-Indigenous woman-led nonprofit that works at restorative justice, land back initiatives, and plant propagating here in Colorado. We live on the land of the Ute, the Cheyenne, the Arapaho, the Kiowa, the Lakota, the Comanche, and 48 tribes, including the Dene, Chicano, and Mexica, that still live on this industrial reservation. I remind you that Colorado is no English name, and you do have the responsibility to uphold its true, authentic integrity. Colorado means muddy red soil. It was told that by the Spaniards when they saw the soil here. Fracking is not helpful in the spaces that we work in now. I literally work in Bennett right now on food farms that feed over 30,000 to 100,000 locally. The very areas in Adams and Weld now have 4,168 fracking permits that have been allowed within that space. This is a long known agricultural belt and soil reanimation space that has been known for this space for generations. I ask that you hold that integrity with protections. This is also an indigenous space that when these tribes are coming back to rename and reclaim sacred spaces for the resources for future generations, which there are several land back initiatives, we ask that you understand the true integrity of your job is to hold the honor of this space by protecting the people and the rights of nature over just corporate benefits. That is not happening. An integrational panel on climate change tells us that 66% of avoiding climate catastrophe by limiting the global average temperature rise no more than 1.5 degrees Celsius, pre-industrial levels, the world must achieve net zero greenhouse gas emissions by the end of 2037, requiring a rapid phase out of all fossil fuels. That is not happening in Colorado, and our quality of life is actually depleting. This year, there has been too many air advisories, and we know that there is too many wildfires for this to continually go on as business as usual with just economic benefits without the health and safety benefits of these communities and disproportionately impacted communities being seen, being protected, and most of all, being required. Last year, the Colorado General Assembly passed SB 19096 and HB 191261, which together established GHG emissions reduction goals for 2025, 2030, and 2050. The oil and gas industry is contributing significantly to the climate crisis through vast methane leaks and then these fossil fuels are burned. We legitimately need you to protect us from serious carcinogens of public endangerment, such as benzene, hydrogen cyanide, and hydrogen sulfide. It is essential to begin making deep reductions as soon as possible. Therefore, state health agencies must begin to chart a pathway away from fracking. I call for all relevant state agencies and divisions to work together to deploy already now a change, not just a bold plan, a legitimate change for rapid and just transition away from oil and gas development in Colorado by 2030, specifically the areas impacted by spaces that I work in that grow our food here. So I ask you for restorative justice for Indigenous communities. We are still here. We do know how to steward the land, and we ask you for legitimate protections at this point. Thank you.
Thank you, Ms. Millard-Chacon, for the comments. Ms. Larson, who do we have next that signed up?
Next, we have Barbara Mills-Bria.
Ms. Mills-Bria, we have made you a panelist. You would need to unmute and we can hear you.
Okay, thank you. My name is Barbara Mills-Bria. I'm a retired structural engineer. I worked in hydropower for 34 years. And the other night I listened to the Windsor Town Hall meeting and I had a few questions remaining. One question that was asked was whether or not the COGCC is interested in assessing the financial viability of each company, as Marie Venner mentioned. And the response didn't address that question. And it seems like the COGCC should be able to say that, of course, we are interested in the financial health of companies operating in the state. So we are hoping that as you address financial assurance and bonding, they're two separate things, you will take into account the damaging impact on public health and safety of the industry and the financial cost and future costs to the taxpayers of Colorado should you decide to not hold companies truly accountable for the damage they do. These companies spend up to $8 million to drill a well, so asking for a cash bond of $250,000 to cover the cost of plugging and reclamation is really reasonable instead of the current insurance scheme that's being used. A recent article about PetroShare's bankruptcy included this sentence: the state lawyers and COGCC arranged $325,000 worth of bonding from PetroShare for the 547 orphaned wells as a part of the bankruptcy proceeding. The COGCC has claimed $265,000 cash portion of the bond and is working on getting access to the rest. So our question to you is, what is the cost to the taxpayers to plug these wells? And what is the cost to the taxpayer for the work getting access to the rest of the money? If the state has to fight to get the money, then this insurance approach does not seem to be a good one. I would like to hear, the second question I have is, I'd like to hear a definition of cumulative impacts, which Director Robbins the other night indicated had been addressed in the new rules, because most of the public have not seen that addressed. To us, cumulative impacts refers to considering the entire impact of all wells, pipelines, tanks, etc., associated with the oil and gas industry, and not just the attempt to get producers to reduce what one well emits. We have seen no desire on the part of the COGCC to address continuous monitoring of this industry so that a true accounting of emissions can be made. And we've seen little done to address the impact of the industry as a whole. Finally, while the bad air quality is consistently blamed on smoke from wildfires, you should be aware that the distant wildfires add to the particulate problem. That's the part you can see, not ozone. Distant fires do not contribute to the ongoing serious ozone issue. That problem.
Ms. Mills-Bria, I
like
apologize for interrupting, but your time is up.
Okay, well, that problem just comes from the NOx produced by the oil and gas industry.
Thank you, Ms. Mills-Bria. Ms. Larson, who do we have next for 3 minutes?
Yes, next up we have Ms. Shana Oliver. And apologies, I thought I had seen Ms. Oliver in the meeting earlier. I don't see her now. We'll continue to look for her. We can move on to Kate Christensen.
Hello. Thanks for taking the time to hear my comments today. My name's Kate, and I wanted to comment on the 2A forms that I've been seeing come in on the COGCC website. I know these are the first 2A since all the rules from the rulemaking that SB 181 mandated went into place. And it doesn't seem like, looking at these citing applications, that anything has changed. Every single one of them is asking for variances or incomplete in some way. Of the 5, there's Longview Farm, which that public comment is closed, but that's like 700 feet from a pond in shallow groundwater. There's Spinney, which in the comment section of the Form 2A says it's very close to nesting bald eagles, but you go further and there's no mention of anything that needs to be done about high priority habitat. So that's totally ignored. I don't know if they're asking for a variance or what happened there. In the federal WMC, it's really close to elk habitat, but they say they don't need to do any light mitigation or noise mitigation. The Belm 18 is within 500 feet of an RBU of a residential building unit. The jet fuel pad is also like 1,400 feet from a residential building unit. So every single one of these is not within the spirit of 181, which is protecting public health, safety, welfare, and their environment. It's like, it'll be interesting to see. I'm curious to see if the commission decides to approve all these Form 2As as they are, because it will tell us whether the rulemakings have made a difference. It'll tell us whether things are business as usual or business as usual, business like pre-SB 181, or if there really has been a change. And we really do care about bald eagles and elk and the safety of people who are, with close to these proposed wells. So yeah, I'm just curious to see what the commission does with all that. Thanks for your time.
Thank you, Ms. Christensen. Ms. Larson, who do we have next?
Next up, we have Guillermo Cerna, who has signed up. Unfortunately, I do not see Mr. Cerna in the meeting, so we'll keep looking for him. We do have Christy Douglas, and we can move on to her.
Can you hear me?
We can, Ms. Douglas.
Great, thank you so much. Good morning, commissioners. My name is Christy Douglas, and I'd like to thank you for continuing to offer remote public comment. I really appreciate that. Before I go on, I'd like to acknowledge that we are indeed on stolen land of the indigenous natives. And if we are not willing to give that land back, the least we can do is stop exploiting the land by fracking it. I don't know why I continue to get nervous speaking to you all. I've been doing this for so many years, and it just continues to rattle me. I'm so sorry. I'm an activist from Commerce City in Adams County. Commerce City is home to the Suncor Refinery, the Rocky Mountain Arsenal, and the prospect of nearly 300 fracking wells. I also serve as the co-chair for the North Range Concerned Citizens, a group of residents in the North Range of Denver metro area that have come together to protect its people from environmental exploitation and the social injustice and inequity that comes from racism and income inequality. I'm here to speak in behalf of all the people who couldn't make it here to speak this morning, and there are many, many people who couldn't make it. I am also here to fight for the futures of my husband and I have 5 adult children and our 5 grandkids, my neighbors, and my friends across the Front Range, and for the families of the oil and gas fracking gas industry workers who have become dependent on fracking as a means of paying the bills, putting a roof over their heads, and food on their tables. So the reason I'm here this morning, I'm here to talk about the recent landslide on I-70, and I want you to think about why that happened. Because it doesn't take a rocket scientist or an in-depth study to figure it out. All it takes is a little observation and common sense to know that it happened, and it was because of the loss of vegetation due to the wildfires that have occurred over the past few years. And whether anyone wants to admit it or not, the increased wildfires are the result of our man-made climate crisis. You are the Colorado Oil and Gas Conservation Commission. And the key word in the name of your agency that you serve on is conservation. I'm going to leave it at that today. Just some food for thought, and I hope you take it to heart and think about it. Thank you.
Thank you, Ms. Douglas. I believe we have your husband, Steve Douglas, is up next.
Actually, he had to go back to work. He's a working guy, 44 years.
Okay.
And
Thank you, Ms. Douglas. We'll move to our next panelist.
So next up, we'll turn to Ms. Tez Dougherty.
Hello, Ms. Dougherty. Are you ready to present to us?
Sorry about that. Can y'all hear me now?
We can.
Okay, great. Thank you. So I just wanted to talk about some research that I have done and talk about, like, you know, the need for centering the regeneration of our land. Land that we occupy, indigenous land of the Arapaho, Ute, and Cheyenne, and 45 other tribes that still have ties to this land, who consider themselves just as much a part of this land as any other living being. And yet, extraction capitalism does the exact opposite. And since 2015, at least 248 North American oil and gas companies have sought bankruptcy protection. In 2020, more than 50 of them with debts totaling more than $50 billion filed for bankruptcy. In July 2019, BP's head of strategy admitted that some of its unextracted oil and gas, quote, won't see the light of day. The world's carbon budget is finite and running out fast. We need a rapid transition to net zero. BP CEO Bernard Looney, that's a funny name, August 2020. According to the IMF, the oil-rich countries of the Middle East risk losing their $2 trillion wealth by 2034, just 13 years from now, as oil demand peaks, then declines. There is not, quote, there is not a regulated coal plant in this country that is economic today, full period and stop. Next Era Energy CEO. The solar energy progress. How do projections compare with reality? In 2002, the projection was that the solar energy market will grow 1 gigawatt per year by 2010. The reality, in 2020, it was exceeded by 132 times. Globally, wind could supply worldwide electricity consumption 40 times over. Investments in solar plus energy efficiency measures turned the Batesville School District's budget from deficit to surplus and led to a $2,000 to $3,000 raise per teacher. 8 of the 10 Louisiana parishes with the highest death rates from COVID are in Cancer Alley. Florida Power and Light has announced it will replace 2 natural gas power plants with solar farms and a new battery storage system. This is from the president and CEO of North Indiana Public Service Company. The surprise was how dramatically the renewables and storage proposals beat natural gas. I couldn't have predicted this 5 years ago. So these are the kind of things
Ms.
that.
Dougherty, sorry for interrupting, but your time has expired.
Okay, yeah, we're just asking you to think about these things. Thank you.
Thank you, Ms. Dougherty. Appreciate your presenting to us. I believe we still have Mr. David Hagan and Mr. Guillermo Cerna who have signed up. Are they with us?
I've been looking and I've not been able to locate either of those speakers.
Okay, very good. We are at 9:58, so we will have accomplished public comment this morning. And with that, we will move forward with our agenda. The next agenda matter is the consent agenda, in which we have 2 hearing officer recommendations under Rule 505. Do any commissioners have any questions or comments concerning consent agenda? I get to look around at you today. Hi. All right, I'm not seeing any questions or comments around consent. With that, do we have a motion to approve consent?
So moved.
Second.
Great, we have a motion and a second to approve the consent agenda. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. And I believe we successfully established that we could do 5 ayes without having overlap with our microphones. So that is awesome. Next on our agenda is the Oil and Gas Development Plan Applications Check-in. I placed this matter on the agenda to remind commissioners that we do have on September 1st, the 3 first OGDP for consideration by commissioners. And I wanted just to remind our stakeholders and staff that the Oil and Gas Development Plan application is the new all-inclusive consideration of a new location, as well as the wells and the DSU associated with it. Previously, before the mission change rules, oil and gas permits were approved administratively by the director. Under our new rules, the Oil and Gas Development Plan comes to commission at a hearing. And again, we have our first 3 OGDPs scheduled for hearing on September 1st. One of those is protested, and we will allow the hearings officer to sort of work through that with the applicant and the protestant. And I just wanted to sort of step back. It's been 6-8 months since we turned on the new mission change rules. I think that we need to understand and recognize that it's taken this period of time to see our first complete technically reviewed OGDPs. I think that we've done a good job of providing staff the opportunity to develop an efficient process that aligns with our goals of the mission change rulemaking. And now I, for one, am excited that we've had some of these new OGDPs percolate through the process and get up to us. I believe, Director Murphy, that we've got close to 20 OGDPs that are in the hopper at this point. Is that right?
Yes, Chair, that's right.
Yeah. And they've been undergoing stringent review by staff. And again, starting September 1, they will come to us for our consideration. And I look forward to the first review of these OGDPs. This review, I'm hopeful, will establish that the Colorado model that we have established is one where environmental protection and safe development of natural resources can coexist. So I'm excited for that initial review, and I'm hopeful that the protective mineral development in the state will set the model for the rest of the nation. So commissioners, dig into your database and start looking at these the new applications, and we will be reviewing them on September 1st, absent other things happening. So that's the update this morning. Director Murphy, did you have anything further on the OGDP review?
I think the only other thing I wanted to add, Chair, is that as of today, what has been noticed has been through completeness, and staff is continuing its technical review of those through OGDPs. Sorry. And we'll get the director's recommendation on those in advance of the hearing. And that's kind of the process that we've laid out thus far, is getting through completeness and then completing the technical review once it's been noticed. And so there will continue to be work done on these. I know the public comment period is open for some, it has closed for some. The same is true of the protest period. We have two different systems in which information is coming in. We have the web forms system, which is where the data for the 2A comes into COGCC system, which ultimately will populate the database. And then also coming in through the e-filing system as it relates to getting this scheduled for a hearing and prepared for a decision, an adjudicatory decision by this commission. So there are pieces moving. COGCC is also in the midst of updating its web form system. And so there's a lot going on in the technical space that affects how people interface with our system, but we are all working to clarify and make that as seamless as possible. If folks are having issues with it, please reach out. We want people to be able to understand the information as it's presented, where it is, and how they all work together. So
Director Murphy, and I appreciate that, and I know that your staff has met individually with commissioners to help us orient ourselves to the different on-base systems. It might be helpful once all of that's turned on that if we could have educated member of your staff do a PowerPoint for the rest of the world so that we can kind of show folks how that's done. And then we can, Ms. Larson, if we could YouTube that so that it's available for folks to be able to go and see, that would help with the transparency to ensure that everyone has an ability to look at what we're doing. We heard from some of the participants this morning that they are already looking, and I just want to make sure that they have a full ability to understand how to sort of work through our systems as those have been changing.
happy to do that, Chair. Thank you.
Yeah. And I want to just reiterate from the review that I've been doing, the substance and integrity of the sheer volume that goes into an OGDP is pretty remarkable. And I'm pretty excited to look at the review the technical review that's been ongoing. And so again, I think what I heard you say, Director Murphy, is that within a period of time and before the hearings for the first OGDPs, we'll get an actual director's recommendation, which sort of will summarize sort of the work that your staff has done on each of these applications. Is that accurate?
You're correct.
You're correct, Chair. And with that, that also signals the completion of staff's technical review of the permit or of the proposal. Sorry, having a red light meaning I have a hot mic is very confusing to me because I drive too much and stoplights are red too. So it might take me a little bit of adjusting.
Not a problem. And everybody bear with us as we work through all of these new microphones and videos and other things as we try to move forward with a hybrid model of having a commission meeting in these strange days. Any questions about the OGDP check-in from any of the commissioners? Ready, good to go. I'll be reviewing our files as we get ready for hearings. With that, the next presentation that was contemplated is a staff presentation on mechanical integrity compliance tracking, but I believe that we had a concern about that and would turn to Assistant Attorney General Kyle Davenport for some comment about that.
Thank you, Chair. And Commissioners, yesterday, August 3rd, I received an email from Counsel for Wild Earth Guardians asserting that today's scheduled staff presentation on mechanical integrity compliance tracking is an improper ex parte communication because Wild Earth Guardians filed a petition for review challenging the director's decision on a Wild Earth Guardian complaint asserting certain operators violated COGCC MIT rules. COGCC Rule 530 provides that, quote, no person will make or knowingly cause to be made to any member of the commission, ALJ, or hearing officer an ex parte communication concerning the merits of a proceeding for which an application has been filed. In my view, today's scheduled presentation does not violate this rule for two reasons. First, because it will be presented in a public hearing. An ex parte communication is a communication with a decision maker, commissioner hearing officer, that does not include the opposing party. Second, because this presentation does not address the merits of Wild Earth Guardian's petition for review. It is a presentation generally discussing the agency's practices and procedures on MIT compliance tracking. The presentation will not discuss Wild Earth Guardian's petition for review or complaint, the operators named in the complaint, or the director's decision on the complaint. An application does not prevent the commission from learning about how its own agency operates generally. Mr. Chair, those are my views and the communication I received. And unless the commission has any questions, I'll turn it back over to you.
Thank you, AG Davenport. So in summary, you feel that if we want to, it's fine for us to hear this presentation on this matter at this point?
From a legal perspective, yes, that's accurate.
I find this a bit frustrating. Believe that the complaining party actually thought this was a good idea at the time that we put it together. And so I find it somewhat ironic that the complaining party now is saying this is not a good idea. We are only trying to understand our processes as we've gone forward with information dockets around these sorts of things. And really, we're just trying to become better commissioners. With that, I guess I look to my fellow commissioners. Do you want to hear about this topic or not? It's really up to us. Commissioner McGowan.
Ooh, my mic is already on. I'm glad I wasn't doing anything inappropriate. I would like to hear the presentation. I think that beyond just what's Wild Earth Guardian's submittal of their complaint about mechanical integrity testing, I think it's would be educational for all the commissioners to learn about what the process is, what's, what staff goes through, how they try to keep the databases up to date, how the public can get information, how we can get information. So I think it would be educational, but I'd be interested in what the other commissioners think.
Commissioner Njapa?
I
It's so weird to see you all in the same room.
It's very strange. But yes, no, I concur. I think it's given the reasons that AAG Davenport has provided, I feel comfortable with moving forward with the presentation.
Bill, John, thumbs up.
I'm good with it. Yeah, I'm actually, I encourage this presentation, as I encourage all presentations, to make us smarter and more informed on our processes, and also an update on it. I was a part of the commission when we did the wellbore integrity rulemaking, and mechanical integrity tests were an integral part of that particular rulemaking. I like to hear updates on how the progress is going for all the things that we do. I don't see being open with our processes and knowledgeable about our processes is a bad thing. And so I am a little confused by the opposition to being more transparent, which seems awkward. So.
Okay, me too. And I think we've established from the record that this is an informational piece. There's no bias being set up. We're just trying to learn our jobs. So with that, if we could bring Ms. Abrams to the panel, we'll move forward with the staff presentation on mechanical integrity compliance tracking.
Hello.
Hey.
Hi. Audio good? Video
Audio
good?
Good, video good.
All right. I'm going to move you over here so I can see you. Good morning, commissioners. I have a presentation. Angelica or Mimi, is this being presented on your end or am I doing it?
You, Ms. Abrams, you can share your screen if that's preferred.
It is. I can do that.
Wonderful.
I think I can. Share screen. Got it. All right. Just gonna scoot up to the top. Thank you for your patience. Can you see my screen?
We can.
Okay. All right. Well, good morning. My name is Deborah Abrams, and
Yeah, actually, your screen
change.
Email.
Yeah, you've switched to the email screen.
Got it. Thank you.
There
Okay.
you go.
Back. Okay. Good morning, commissioners. My name is Deborah Abram, and I'm here to present to you an overview of the mechanical integrity test compliance process. I'm an engineering technician here at the COGCC, and but I started my career as a geologist. I have a master's in geology with a concentration in environmental geophysics. My education brought me to being a petrophysicist for 7 years prior to joining the COGCC, where I started as a permitter and have been in my engineering technician role for 2.5 years. 2 of those years, I have been monitoring the state's well integrity, mechanical integrity process. So just to go over a brief overview, I'll be providing you with an introduction of the topic at hand, followed by the related rules that are in question on the topic, and then walk you through what the mechanical integrity test audit process looks like for the engineering group. Ultimately, it leads to some warning letters, the deadlines for those warning letters and follow-up, and then finally the enforcement referral process. I'll be closing out with an opportunity for questions at the end. So what is a mechanical integrity test? MIT, as we like to call it, is a pressure test that's conducted on the well, where we're able to identify if there's a significant leak that's in the well that can occur at the casing, the tubing, a mechanical isolation device downhole, and it can also identify any significant fluid movement in the annulus of the borehole. So let's look at this Wellbore diagram briefly, and I can just show you kind of the value of the Wellbore diagram. What I love about these schematics is that it shows the wellbore's configuration in profile. So you are able to see, you know, an enormous amount of information in a single image. For example, this one, as an example, has the casing depths for the surface casing and then the production casing. And then it also shows in pink the cement column that separates the wellbore from the formation. In that graphic as well, it shows the cement column away, separate from the water-bearing formations. We get formation tops provided that also include the hydrocarbon-bearing formations farther downhole. And I forgot to mention that yellow is the uncemented Bradenhead annulus. Also, Wellbore diagrams show us the depth of any isolation devices downhole, such as this one in the schematic, and in the event of an injection well, it also identifies the purple, which is the water disposal zone. So pictures worth 1,000 words, and these drawings, these schematics are very valuable for understanding a wellbore's configuration. Okay, so now that we understand wellbore configuration and the concept of the MIT, what does this mean? Well, I like to think of it as an air mattress. When anyone who has ever slept on an air mattress knows that when it's structurally sound, then you apply your body weight to it, and if it's structurally sound, then you have a good night's sleep. However, the tiniest pinhole, over a period of time, all of that air will leak off and you'll wake up on the floor. It's the same with a mechanical integrity test. We are applying pressure, we're sustaining it over time, and identifying if there are any leaks. So the wellbore configuration and the response to applied pressure both directly assist in our mission to protect the public health, safety, welfare, the environment, and wildlife resources. Now, as part of the compliance audit, we have a standard operating procedure which identifies any wells in the state that may have either missing documentation or MIT non-compliance. So when an MIT needs to be conducted, then all of our guidance documents are available on the website. Under regulation operator guidance, and then searching for mechanical integrity. There are practices and procedures available there and test instructions to conduct the test correctly. It also instructs operators to submit a Form 42, which provides a 10-day notice to our field inspection staff so that they have the opportunity to go out and witness an MIT. Now, if there's equipment downhole in a wellbore, then equipment may need to be removed in order to conduct the test. So a workover rig could be required. If that's the case, then a Form 42 for a move-in rig up is also required to be submitted with 10-day notice. And that form notifies the local and proximate governments of a workover rig being present on site. Ultimately, it can be a multi-day operation to remove tubing and install or remove any downhole isolation devices. So let's bring it to the rules. The rules, a number of rules are involved in addressing compliance for MITs, but these are the main four. And we rely heavily on production reporting. This is the monthly operators production reporting that they self-report. And it's important because we have a monthly update on the status of the well. The status is really important for determining the frequency that MITs are required to be conducted. So the wells in the state fall under these four categories for MIT compliance. They're temporarily abandoned, they're shut in, they're injectors, or they're awaiting completion and have suspended operations. When an MIT is conducted, then a Form 21 needs to be submitted reporting the results of the test within 30 days. And then if a well is temporarily abandoned, then the MIT is required within 30 days of abandonment. Okay, so the engineering audit is very extensive and comprehensive. It's broken down into two parts, the preliminary part of the audit. It starts with a SQL query, and SQL is just the pronunciation for SQL, which is a structured query language. It's basically enormous lines of script that scan the entire COGCC database, we call COGCC, for any late or missing form submissions. So it's scanning for forms and then the relative dates based on those statuses. So all that information is being queried to create an enormous list that's output. Now, the list needs to be vetted. So I go through in a comprehensive audit, well by well, looking into each file to validate the query's results. And I often find a number of, I can identify inconsistencies or inaccurate reporting. I can identify rule violations. And while I'm in every well file, I can correct any reporting errors that can be addressed easily. Now, as a part of that output and subsequent comprehensive audit, warning letters are issued. And they go out via email to the operator's principal agent as a notification. Now, it's important to note that supervisors have the authority to escalate a case to enforcement directly without issuing a warning letter as well. But when warning letters are issued, they identify the alleged rule violation, they provide instructions to return to compliance, a corrective action due date, and identify the point of contact at the COGCC to direct any questions and or their resolution. Once those corrective action dates have passed, then there's a follow-up audit that's conducted for all of the wells that were issued warning letters. And the audit is looking for an assurance that the corrective actions were met by the due date. That list is then cross-referenced with engineering and orphan well program supervisors to get their confirmation and verbal approval to proceed in the event, that they need to be escalated to enforcement. And then finally, The wells that have not met their corrective actions are referred to the enforcement group for a notice of alleged violation to be issued. So in summary, I want to make a point that the audit relies heavily on accurate reporting, and especially in our field inspection reports, our field inspectors out in the field are reporting back statuses as well that fill in the gaps often in where reporting may have lapsed. And then the warning letters are an excellent tool for establishing communication with our operators because they have the opportunity to reach out directly to their point of contact, ask any questions, and ultimately achieve compliance. And then finally, any violators of an MIT non-compliance are escalated and referred to enforcement. Thank you very much. If you have any questions, let me know.
Thank you, Ms. Abrams, for the presentation. Looking to my fellow commissioners if anyone has questions. Commissioner Nanjapa?
Thank you, Mr. Chair. And thank you so much, Ms. Abrams, for the presentation. That was really informative and helpful. One question I had is when you're doing the SQL query of the database, and that's specifically looking for the missing or late forms, have you done additional sort of auditing to see if that query is missing instances where there is non-compliance, but it, maybe has been misrecorded?
So, and in the 2 years that I have been doing the MIT compliance audits, we've had a number of conversations on opportunities to upgrade and tweak the query, which have been brought to our OIT group, yes. And it's ongoing.
Commissioner McGowan?
Thanks for that presentation. It's always helpful to learn more about what's going on. And I'm sorry if you said this and I missed it. How often is the audit run to see if everyone's in compliance?
So the terms or the periods of the audit change sometimes, but currently they're being done biannually. And that also includes the follow-up and the deadline compliance follow-up, for the corrective action. So this is kind of a revolving door of events revisiting wells throughout the year, but the SQL query is conducted twice a year.
Twice a year.
Twice a year.
Yeah.
Further questions? Go ahead, Commissioner
Thank you,
McGowan.
Mr. Chair. So after you run the audit and we determine whether someone's actually in compliance or not, or they've been given a letter, how is all of that updated in COGCC and how do we try to keep that database updated? Because I think a lot of folks depend on it to get information about compliance by operators. And so I'm just curious to know how that works.
So the paper trail is kind of created when the NOAV is issued. So the enforcement group does their own comprehensive investigation to determine which rules are going to be addressed in the NOAV. So between the audit and the NOAV they're doing deep dives into the database to ensure that all of the forms are accurate, and communicating with the operators to see if they can be brought into compliance before during the NOAV process.
Chair.
Yeah,
I think,
Director Murphy?
Deb, can you talk a little bit, thank you, that was excellent, by the way. Can you talk about a little bit before that, from the time an operator submits notification of performing an MIT, and then the timing between that and review and getting that document posted and publicly available?
Yeah, so the Form 42 is a great indicator of when the operations are set to commence. And it has a 10-day window, so oftentimes, operators will submit more than one in the event that they have delays, but that contributes to the paper trail as well, including the inspection reports, which often cite that an MIT has occurred. All of this is kind of building the story of the MIT compliance while paperwork is coming in by the due date. Did I answer your question?
Director Murphy, you want to, or Commissioner McGowan?
A little bit. So, so my guess is staff is responsible for keeping COGCC, I'm going to put in quotes, up to date. And so if an operator is in compliance, it is possible that the staff might be behind in saying, oh yeah, they did it, and reflecting it in the database. So having personally gone into COGCC to look for things, it's hard for me to tell who's responsible for saying, yes, this did happen, or yes, this follow-up occurred, and keeping it as up to date as possible. Does that question make sense?
Yes, it does. And I can add a piece to this puzzle also by making a point that the wells, so the forms and the documentation that exists in COGCC are only the ones that have been approved. So a Form 21 that reports the results of an MIT is awaiting review by an engineer as well. So that wouldn't appear as in the public database until it's been passed. And engineers are constantly working through the queues of their forms to bring everything up to date and stay up to date with all of the forms that are awaiting review. So there is a lag, and that's one of the things that's part of the audit and part of the communication with operators, because a number of times a form will be in process, but the SQL query doesn't identify in process forms, or it doesn't distinguish between them. So sometimes, precisely to the point about internal correction, being able to make small changes and corrections to the reporting as they come along, is that if I see an in-process form that hasn't been reviewed, I can direct that to an engineer to be reviewed so that the database can be updated.
Thank you.
Further questions? Commissioner Messner?
Thank you, Mr. Chair. Thank you for the presentation and the information, Ms. Abrams. I wonder, and this may be off topic a little bit, but I wonder if you could talk a little bit about what steps happen if a operator fails an MIT test, and what are those next steps in order to get that operator back into compliance?
Sure, I can speak a little bit to that. My role is exclusively in addressing the audit. So if an MIT fails, it kind of goes into the area engineer and the supervisory level of remediation of the well. However, depending on whether or not the test was conducted within the predefined intervals of the frequency, an operator has a given period of time to remediate or plug the well. So there are some circumstances, if the mechanical integrity test was conducted prior to its due date, then I believe they have 6 months to plug the well. If they exceeded the interval that's predefined by the rules, then that is significantly cut down. I believe the rule says 90 days or 3 months. And as part of that remediation process, forms need to be submitted for approval for remediation or plugging, etc. So there are a lot of cooks in that kitchen.
Commissioner Messner, follow-up?
No follow-up, thank you.
I'm looking side to side because we're all in the same room together. I'm not seeing further questions. Ms. Abrams, thank you so much for the presentation and the education that you provided to us and to our stakeholders this morning. It was very well done.
Thank you.
Okay, commissioners, with that, we are to the last item on our agenda, which is any commissioner comments for the good of the cause. Does anybody have anything further for us this morning? Commissioner Messner.
Thank you, Mr. Chair. I just have a question. If I remember right, we had Brett Ackerman from CPW scheduled at some point in the past, and we were going to reschedule him. Do we know when that might be?
Director Murphy?
It may have fallen off my radar in the last 2 months, but I will happily ping Mr. Ackerman and get him in to have a conversation about that. Thanks for the reminder.
Great, thanks.
The only comment I have, as was noted by some of our public commenters, we as commissioners are continuing in our outreach, and I did said outreach to the town of Windsor on Monday night. Had a good hour-long dialogue with those folks, gave them a heads up on what we've been doing. They seem to be pretty receptive to what we're doing, and they don't regulate oil and gas, and they rely on us to do that. So just FYI, and had a good outreach with that community. And John Messner and I continue in those outreach to local governments who desire to hear from us. So there you go. With that, Commissioner McGowan.
Thank you, Mr. Chair. So I think, I'm looking to Mimi. I think we talked about some sort of presentation when the system is ready to share with folks how they can find OGDPs and all the pieces to the permit. And I know that we're not ready yet, but I just wanted, for folks who are still listening, that there will be some sort of a 101 on how to navigate and find all that information for folks who want to jump into the system and find that. And then my other comment was Miss Mills Bria Mills. Mills Bria asked, what we were doing to address cumulative impacts. Is there some way next week maybe we can just post? I sent her some places where I am familiar where we tried to address cumulative impacts already in the rulemaking, but can we send her some information about where those are located in the rules so she can see what we've already done to date regarding cumulative impacts?
Certainly, we can send out to her our rule sites and note where they are available to the public on our website.
Thanks.
Great. Thank you, Commissioner McGowan, for being responsive there. With that, I see that we've got Deputy Director Cuthbertson in the room with us, and I just want to send a shout out and thank you for all the good work in establishing a safe and effective environment for a hybrid format meeting. Seems like it went off well today. I know you were zoomed in. Did it look okay to you from a outside perspective?
Yes, sir. Very good.
Great. Well, thanks again, Scott, for the work that you're doing. Thanks to everyone for being with us. We've still got 86 some odd participants. We're going to continue to slowly work into this hybrid format. As we announced at, I think, the last meeting, we're still not in a place where we will have public within the rooms, but we'll try to take the next steps to have meetings in which we're together and we can see each other and see head shakes and all that sort of stuff. So seeing no further comments, I think we're looking for a motion to adjourn.
So moved. Second.
We have a motion and a second to adjourn. All those in favor signify by saying aye.
Aye.
Thanks, everybody. We do have a work session Friday at 10 a.m. Those are bi-weekly. We do not take public comment at those work sessions, but that's the next time this group will get together, and you're happy to zoom into that meeting if you so desire. See you then.